Hi guys, my name is Nishil Kaushal and I am currently interning with the LEXIS and Company, and today I will talk about the difference between the contract of indemnity and the contract of guarantee, and basically the essentials of the indemnity. So according to section 124, the contract of indemnity means a contract whereby one party promises to save the another from loss caused to him by the conduct of the promiser himself or by the conduct of any other person. The primary object of an indemnity contract is to protect the promisee against the anticipated losses. Now, a contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. In every contract of guarantee, there are three parties: the creditor, the principal debtor, and the surety. There are three separate contracts. Firstly, the principal debtors make a promise in favor of the creditor to perform himself, makes a promise to perform a promise, etc. Secondly, the surety undertakes to be liable towards the creditor if the principal debtor makes a default. Thirdly, an implied promise by the principal debtor in favor of the surety that in case the surety has to discharge the liability on the default of the principal debtor, the principal debtor shall indemnify the surety for the same. Thus, both indemnity and guarantee are devices for providing protection against a probable loss due to human conduct. However, there are some distinguishing features between them. Now, in contract of indemnity, the contract of indemnity is a contract whereby one party promises to save the other from loss caused to him by the conduct of the promiser himself or by the conduct of any other person. And in contract of guarantee, a contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. In contract of indemnity, there are two parties in the contract of indemnity, which are indemnifier and the indemnified. And there are three parties in the contract of guarantee, which are the creditor, the principal debtor, and the surety. In contract of indemnity, it is made for reimbursement for loss. A contract of guarantee is to provide necessary security to the creditor against his advances. In contract of indemnity, the liability of the indemnifier to the indemnified is primary and independent, and in the other case, the liability of the surety to pay the creditor is collateral or secondary, the primary liability being that the principal debtor. Now, in contract of indemnity, there is only one contract in case of a contract of indemnity between the indemnifier and the indemnified. And in case of contract of guarantee, there are three contracts in case of contract of guarantee, which are between the principal debtor and the creditor, between the creditor and the surety, and between the surety and the principal debtor. It is not necessary for the indemnifier to act at the request of the indemnified, and in the other case, it is necessary that the surety should give the guarantee at the request of the debtor. The liability of the indemnifier arises only on the happening of the contingency. On the other case, there is usually a existing debt or duty, the performance of which is guaranteed by the surety. An indemnifier cannot sue a third party for loss in his own name because there is no privity of contract. And on the other case, a surety, on discharging the debt due to the principal debtor, steps into the shoes of the creditor. Now, what are the essential features of indemnity? So basically, a valid contract of indemnity should fulfill the following conditions. First, anticipated losses. A contract of indemnity is a security for an anticipated loss. Second, requirements of a valid contract. Contract of indemnity, being a species of contract, must have all essentials of a valid contract, like free consent, competence of the parties, consideration, etc. Third, to save the other party. There must be a promise to save the other party from some loss. Fourth, it covers only the actual loss. So basically, it covers only the actual loss, may be due to the promisor himself or any other person, and it covers only the loss caused by an event mentioned in the contract. The event mentioned in the contract must happen. Fifth, it may be expressed or implied. The contract of indemnity may be expressed or implied. An express promise is one where the person promises to compensate the other party in express term. An implied promise is one where the conduct of the promiser shows his intention to indemnify the other party from loss. And last, it depends on good faith. The contract depends on good faith. Thank you.